Dear students, the topic of the day is Reservation Policy in India, a critical study with reference to creamy layer principle. Caste or no caste, creed or no creed, or class or caste or nation or institution which bars the power of free thought and action of an individual, even so long as that power does not injure others, is devilish and must go down. Swami Vivekanand. Introducing the topic, reservation is a strategy intended to address previous perceptions against weaker as well as minor groups by means of educational and financial improvement measures. Reservation can be described as an effort to advance equal opportunities in government and educational institutions. It is often instituted for ensuring that minor groups are involved in every program within the community. The reservation justification is to offset a culture's ruling class for earlier exploitation, persecution or discrimination for resolving present discrimination. Reservation in India are processes in which participants of other backward caste, scheduled caste and scheduled tribe have certain proportion of position, that is vacancies in public organization. Reservation is a quota oriented affirmative action where a position's proportion are reserved for academic and social backward groups. Definition of term reservation. There are various views propounded by experts. As per encyclopedia, the reservation is described as a reserve is the supply for future use or something separated for a specific purpose. Types of reservation. The quota system lays separately for employees of a particular community a percentage of all feasible roles. Those who don't belong to the groups can only compete for other roles, while the reserved groups may contend for all the roles. For instance, if two among clerical posts in the railways are reserved for ex-soldiers, both the general classification and the particular quota are open to competitors in the military. Caste-based reservation. Seats shall be reserved by central government and the state government for scheduled castes, scheduled tribes and other backward castes. The caste can never be altered and chosen on the basis of birth. While an individual can modify his or her religion and his or her financial position, the caste is constant. Scheduled caste learners as well as scheduled tribes are reserved with 22.5 accessible position in central government funded greater educational organization. By addition of an extra 27% for OBCs, this proportion of reservation has been increased to 49.5%. 8% of the slots for AIMS are reserved for STs as well as 14% for SCs. Furthermore, only 50% SC and ST learners are qualified. Also, in every election where some constituencies are allocated for definite group as well as in the parliament, the proportion is observed. In several states such as Tamil Nadu, 18% of the reservations are focused on local demographics and 1% for STs. In Andhra Pradesh, 4% schools as well as government employments are reserved for Muslims, 6% for STs, 15% for SCs and for 25% for BCs. Religion-based reservation. The government of Tamil Nadu allocated 3.5% seats to Christians and Muslims each, and therefore changed the OBC allocation from 30% to 23%, as it does not include individuals of the other backward groups who are either Christians or Muslims. The reasoning of the government states such subquota depend on social groups and not individuals. The Andhra Pradesh government enacted a law allowing Muslim reservation of 4%. It was challenged in the court. A 12% threshold for Muslim is available in Kerala Public Service Commission. Educational institutions with religious minority status also have a 50% reservation for their beliefs. State of domicile. All employment under state governments with few exceptions are reserved for those resident under that state. In Chandigarh, 80% of the position were reserved for Chandigarh domiciles previously, but now it is reduced to 50%. Undergraduate colleges. Institutes such as GIPMER follow a reservation policy for GIPMER postgraduate students. In All India Institute of Medical Sciences, seats have been reserved for those who complete degree of MBBS from the institute. Reservation for women. Exclusive organizational women's education, which can be viewed as sort of reservation. Deserted female and widow reservation. Government transport reservation in some countries. Reservation for economically weaker section. In 2019, the central government declared 10% reservation to the economically weaker sections by 103rd constitutional amendment. The Supreme Court has also upheld the constitutional validity of this provision. Legal provisions in India regarding reservation. The government policies related to society's minorities in primary structure, for example, special treatment keeps on being connected in the United States of America, while in India, Malaysia, South Africa and Brazil, it fundamentally appears as standards or reservations. We are comparing Indian reservation system with one prevalent in other countries. Taking everything into account, it tends to be said that the selection of the governmental policies regarding minorities in society arrangements in these 8 unique nations contrast in substance as the varying need of the financial conditions request. Be that as it may, the crucial responsibility of the mission for just and meet social political requests continues as before. Be that as it may, paying little mind to the immense number of ways these laws and policy might be connected, it is very clear that they are regularly basically required for making genuine any guarantee of correspondence. Be that as it may, this relative methodology ends up valuable in those encounters for gaining from such practices in one nation improves another nation. In such manner, despite the fact that it is critical to take a gender at the encounter of different nations, yet the methodology of one nation must not be received by the other nation without giving due thought of its own particular history and the Indian Constitution. Article 15, Clause 4. Special provision for advancement of backward classes. Article 15, Clause 4 is an exception to Provisos 1 and 2 of Article 15, and it was included by the Constitution First Amendment Act 1951 because of the choice in State of Madras versus Champam Doraijan. For this situation, the Madras government had held seats in state medical and engineering universities for various networks in different extent based on religion, rank and race. The state protected the laws on the ground that it was authorized so as to advance the social equity for every one of the areas of the general population as required by Article 46 of Directive Principles of State Policy. The Supreme Court held the law void since it ordered understudies based on station and religion independent of legitimacy. To alter the impact of the choices, Article 15 was changed by the Constitution First Amendment Act 1951. Under this condition, the state is enabled to make arrangements for the progression of any socially and instructively in reserved classes of resident or for the scheduled caste and scheduled tribe. After the change, it wound up workable for the state to set up Harijan colonies so as to propel the enthusiasm of the retrogressive class. Constitution 93rd Amendment Act 2006. Provisions for reservation of backward SC and ST classes in private instructive foundation. Article 15, Clause 5. The new condition 5 gives that nothing in Article 15 or in sub proviso G of Clause 1 of Article 19 will keep the state from making any exceptional arrangements by law for the progression of any socially and instructively in reverse class of resident or for scheduled caste or the scheduled tribes in so for all things considered uncommon arrangements identify with admission to instructive foundations including private instructive establishment regardless of whether helped or unaided by the state other than the minority instructive organization alluded to in Clause 1 of Article 30. The previously mentioned alteration has been instituted to invalidate the impact of 3 choices of Supreme Court in TMAI Foundation versus Provinces of Karnataka, Islamic Academy versus Provinces of Karnataka and P.A. Inamdar versus Territory of Maharashtra. In T.M.A. Pai and P.A. Inamdar case, it has been held that the state can't reserve a spot of seats in affirmations in secretly run instructive organizations. In Islamic Academy case, it has been held that the state can fix quantity for admissions to these instructive organizations, yet it can't fix charge, and furthermore, affirmation should be possible based on regular confirmation test and based on legitimacy. This amendment empowers the state to make arrangements for reservation policy for the above classification of class in admission to private instructive establishments. The amendment in any case keeps the minority instructive foundations out of its domain. Article 15 denies segregation on the ground of religion. The detestable impact of reservation is outstanding. The government officials who guarantee to take the nation to the 21st century, for which advanced education depends on legitimacy is basic, is making a retroactive stride in giving reservation to less worthy understudies to private instructive establishments. This mollification strategy of the legislature may get them some advantage in decisions. However, it is hurtful to the nation. In Article 15 of the Constitution, Clause 6 shall be inserted after Clause 15, Clause 5. The state shall not be prohibited from making, either by this article or subclause G of Article 19 or by Article 29, either in Article 19 or in paragraph 2. Specific clause to further any socially poorer group of people other than the classes alluded to in subsections 4 and 5 and B. Any special requirement to encourage the admission to education institution like private educational establishment, whether supported or assisted by the state other than minority educational institution referred to in Article 1, shall apply so far to any economically poor division of people other than those referred by Clause 4 and 5. Reservation of posts in open work based on habitation. Article 16 Clause 3 is an exception to condition 2 of Article 16, which prohibits separation on the ground of living arrangements. Be that as it may, there might be valid justification for holding certain posts in state for inhabitant as it were. This article engages Parliament to manage by law the degree to which it would be reasonable for a state to leave from the above rule. Reservation policy for in reverse class in open work. Article 16 Clause 4. Article 16 Clause 4 is the second exception to the general standard typified in Article 16(1) and 2. It engages the state to make uncommon arrangement for reservation policy in arrangements of post for any regressive class of resident which in the sentiment of the state are not sufficiently spoken to in the administration under the state. Indrasani versus Union of India, the Mandal case. The 9-judge Constitution Bench of Supreme Court by 6:3 dominant decision held that the choice of the Union government to save 27% government employments for in reverse classes gave socially propelled people creamy layer among them are wiped out is naturally substantial. The reservation policy of seats will just restrict to introductory arrangements and not to advancements, and the all-out reservation will not surpass 50%. The court in like manner halfway held the two criticized notice OM dated August 13, 1990 and September 25, 1991 as legitimate and enforceable, however, subject to the conditions demonstrated in the choice that socially propelled people that creamy layer among backward classes are prohibited. Nonetheless, the court struck down the Congress government's OM holding 10% government employment for financially in reverse class among higher classes. After milestone of Mandal case, Article 16(4)(a) through 77th Amendment and Article 16(4)(b) through 81st Amendment were included. As per condition 4A, nothing in this article will keep the state from making any arrangement for reservation in issues of the advancement to any class or classes of post in the administration of state for scheduled caste and scheduled tribe which in the assessment of the state are not enough spoken to in the administration under the state. Section 4B looks to end the half roof on the reservation policy for SC, ST and BC in overabundance opportunity which couldn't be topped off in the earlier years due to the non-accessibility of qualified competitors. 85th Amendment Act replaces the words in issue of advancement to any class in proviso 4A of Article 16 with words in issue of advancement with significant status to any class. Article 16 clause 6 inserted after 16 clause 5. The state, in addition to the current reservation and subject to a limit of 10% to the place in each subclass, shall be exempted from this article by nothing from rendering any provision in support of any economically weaker group of people other than classes mentioned in clause 4. Reservation in present time. The Indian Constitution includes Article 15 where the 6th clause was inserted naming the Article 15 clause 6. Nothing in subclause G or Article 19 clause 1 as well as Article 29 clause 2 can prevent the state for providing any special provision for any socially disadvantaged citizens parts other than the groups alluded to in clause 4 or 5 to be promoted. Any special arrangement for the furtherance of any special disadvantaged population segments other than those alluded to in clause 4 or clause 5, clause of Article 16 in the Indian Constitution where the 6th clause was added after the 5th clause. Article 15 clause 6, not even a single clause of this article would prohibit a state except for the current reservation by subjecting to a limit of 10% of the jobs in every group extending from preserving any reservation in the post or appointment in support of all economically poorer part of the people other than those alluded in 4th clause. In Bhakta Remgowda versus State of Karnataka, it was laid out by the court that vacancies not filled by SC or ST will be treated as a backlog and would be filled in future. Union of India versus Indira Sani. 9-judge bench laid out that number 1. The reservation should not be more than 50% but in exceptions can be considered. Number 2. Reservation in Article 16 clause 5 only at the time of entry in the government employment and not in promotion. Number 3. Creamy layer must be excluded. Number 4. The reservation is a subjective satisfaction under a state. Number 5. Backwardness could be determined and identified not only by economic criteria but with income, caste, occupation. Article 16(4)(a) formed by 77th Act of Amendment enables the reservation in promotion. In State of Punjab versus R.K. Sabharwal, the constitutional bench laid out that once these seats are filled by reserve category, roster ceases to exist. Percent of reservation is to be seen by number of posts in the cadre strength and vacancy here has no meaning. Roster shall start opening from 10th Feb 1995. In case of Union of India versus Veerpal Singh, 2 judges bench held that state provide that even if the SC candidate is promoted earlier, the general candidate when promoted will acquire same level of seniority as in lower level. This is called as catch-up rule. In Ajit Singh Januja versus State of Punjab, 3 judges bench held that catch-up rule more elaborately said that the seniority between the reserved category candidate and general candidate in promoted category shall be same as in the lower grades. SC and ST will be given reservation to the extent as 15% for ST and 3% for ST. This will operate till the reservation in the cadre for SC becomes 15% and 3% for scheduled tribes. When backlog cleared, the reservation of the scheduled caste and scheduled tribes in a particular cadre should be 15% and 3% respectively. In case of Jagdish Lal versus State of Haryana, 3 judges bench said that principle of continuous officiation was propounded that the reserved category candidate, if promoted earlier due to reservation, will not lose seniority in the higher cadre even if that promotion was accelerated. The conflict arose. This was resolved in Ajit Singh versus State of Punjab number 2. The constitutional bench upheld the catch-up rule for determining the seniority of the roster point promotion and the general category promotions. In case of M.G. Badapnav versus State of Karnataka. 3 judges bench relied on Ajit Singh 1, Ajit Singh 2 and R.K. Sabharwal. The promotion due to roster, if given seniority, would violate the right to equality as basis structure of the Constitution and order to review the promotion list after 1st March 1996. 85th Amendment came in 2001, which is effective from 17 June 1995. The purpose was to give consequential seniority to reserved category promotees. Consequential seniority is if A and B are working in the same level 1 and A is a general candidate with 3-year seniority and B, because roster points get promoted, being in reservation to level 2 earlier to A, and A gets promoted to level 2 after 2 years. Now, consequential is B will continue to be a senior to A because he came to level 2 before A. Catch-up rule, B will again become junior to A because A has more experience than B in the employment. The validity of 77th Amendment, 85th Amendment and legislature made in pursuance of the same were challenged before the Nagaraj case. Controversy regarding reservation. It is pertinent to mention here that reservation is the most controversial issue in India. The persons who are belonging to upper caste are opposing the idea of reservation as it is going to affect their chance for getting admissions in educational institutions and in government jobs. On the other hand, the socially and economically backward classes justify the need of reservation for curing social and economic inequalities in society. The reservation was meant for a limited period by framers of the Constitution, but instead of abolishing, it is being extended without any limitation. In India, caste is considered to be the main criteria of backwardness for grant of reservation. The people of upper caste argue that social and economic conditions should be taken into consideration while giving reservations. Moreover, it is also emphasized that the person who are actually in need of reservation benefit don't get the benefit of it. The reservation based upon caste is becoming a controversial issue with the passage of time and is disturbing harmony of society. It is also felt that the person who are benefited by reservations are generally educationally and socially more forward among the reserved categories. It is observed that the families who have got the benefit of reservation are availing these benefits time and again, whereas those who have not got any benefit of reservation are being deprived of the same. Hence, among the reserved categories also there is a feeling of resentment. Thus, the present policy of the reservation is encouraging social disorder among various sections of the society. The children of our administrative officers, member of parliament, members of state legislative assembly are getting benefits of reservation, whereas the poorer and the illiterate section of SC, ST and backward classes are being deprived of the benefit of reservation. Another peculiar problem regarding reservation is that more and more forward castes are agitating for their inclusion in other backward classes. As already mentioned, Marathas, Patels, Jats and Coppers are also making a demand for their recognition as other backward classes. This demand reflects the difficulties being faced by them in the government job. The lack of jobs in the job market is one of the important reasons for increasing demand of more and more communities to agitate for reservation in job. The Indian economy is not creating as many jobs as are required for educated youth. There is a very serious issue. There is urgent need to give thought to this demand which is increasing day to day. It is also argued that due to reservation the merit is ignored and there is compromise regarding quality and intelligence in public employments. The children who are less meritorious are able to get jobs and are able to get admissions in prestigious educational institutions upon the basis of reservation, whereas more meritorious students belonging to unreserved caste or class are denied jobs and admissions. It is argued that it is a very dangerous trend and one of the reasons of the brain drain in India. For welfare and development of the society and country, merit should not be ignored while giving jobs in public employment and in giving admissions in institutions. The intellectual strata of society argue that reservation should be based upon economic criteria, but the government is taking the plea that it is very difficult to judge the economic condition of a particular family to find out whether the family is socially and economically backward or not. In addition to this, in some communities of OBCs, there is a serious intercaste economic differentiation and there is inter-caste conflict among some OBCs community. The reservation has become a birthright in perpetuity in our society. The provision of reservation was made for the upliftment of weaker section of the society, but unfortunately, the required progress has not been made even after a lapse of 70 years. On the other hand, reservation policy has divided the country on the caste line, and inter-caste conflict are going to increase day by day. In this conflict, the bigger sufferer is the poorest of the poor among the people from the upper caste, and no one is serious about the problem of such persons. Hence, it is argued that the caste-based reservation should be changed into need-based reservation. In addition to this, demand of reservation is increasing day by day. The Supreme Court has laid down reservation should not exceed 50% of the available seats or jobs, so that substantial number of seats or jobs are available for open competitions and persons belonging to unreserved caste or communities. However, in some of the states, the reservation has exceeded the limit of 50%. In addition to this, another bone of contention is the reservation in promotion as far as government jobs are concerned. According to Article 16(4)(a) of the Constitution, the state has right of making provision for reservation in matter of promotion with consequential to any class or classes of the post in service in favor of SC or ST which according to state are not adequately represented. It will be clear case of discrimination when two persons who had joined the job on the same day are treated in a different manner in the matter of promotions. This creates unnecessary heartburning among the employee and has an adverse effect upon their efficiency of work. Reservation is being used as a political trump card for votes, and it is not based on need of people. The biggest drawback regarding reservation is that it is dividing the society on communal lines as was earlier. It has been observed that Dalits and other communities put in reserve categories are in targeted time and again. Further, reservation in legislative bodies has divided the SC/ST community as each community wants ticket for a person's belonging to its own community. This division can be observed at the time of distribution of tickets during parliament and assembly elections. The people of a particular community want to grab more and more seats so that they may be able to have a major share in government and in administration. Thus, the reservation has become a controversial issue in the present time. Though some people of the SC/ST and OBCs have been benefited by reservation, yet its benefit have not been availed by needy and poorer persons of these communities. It is the pious duty of the state that benefits of the reservation are made available to the actually needy and deserving people. With the passage of time, there are changes in the society. All the policy and schemes need to be modified and changed according to the changing needs of the society. If no change is made by the government, with the passage of time, there are chances of resentment and agitations which are not good for the society. Conclusion. In the end, it can be concluded that there is an urgent need to give thought to the whole policy of reservation in India. The reservation policy should not be used as a tool for voters in election. The political leaders of the various parties should think about the all-round development of the society in India. If they will discard their petty interest and think about the welfare of the society, the real goal of the constitutional framers will be achieved. I hope this lecture is useful for you. Thank you and have a nice day.